Disclosure meetings. This is where the patent attorney meets with the inventors to discuss their invention. In this meeting, the goal is to gather as much information as possible to prepare a patent application. Often, follow-up meetings, calls, and emails will be needed to gather additional information. For startups and sole inventors, we recommend that you prepare a short outline of your invention and sketch up as many drawings you think will help explain your invention. Don't worry about the format and focus on providing as much information as you think is useful to describe your invention. For example, if your invention relates to a piece of hardware, a circuit, a software solution, or mechanical device, you should provide as much detail as possible. Inventors working for established companies are probably familiar with the Invention Disclosure Form, or IDF. Even if you work for these companies, you should spend extra time to include drawings, screenshots, pictures, flowchart, or any material that will help the patent attorney understand the invention. Some companies have patent committees that meet to decide to file or not file your invention. If you don't provide enough information in the IDF, the company may pass on filing your innovation, which can also hurt the company by not protecting its investment in the research and development of the technology. At the disclosure meeting, we recommend that inventors provide a short verbal description of the prior art or why there is a need for the invention. Sometimes this can be accomplished by describing how existing solutions fail to achieve the result or simply do not work. This background is important as it helps provide context for your invention. Once the background is discussed, we recommend inventors to provide a verbal description of their invention at a high level without diving into the weeds. Once the high-level discussion is finished, we usually ask the inventor to explain more finer details of the invention. As the inventor explains these details, we typically ask the inventor to expand or explain further certain details. We do this to better understand what part of the innovation is truly unique. In the meeting, we also encourage inventors to hand draw any examples and further expand on the novelty or share their screen if the meeting is conducted by phone or via a web meeting. The meeting usually takes between 1 and 2 hours, and the attorney should have enough disclosure material to proceed with the draft patent application. In more complicated inventions, follow-up meetings are often required. The goal of the entire process is to provide your attorney with all the information necessary to draft a solid and comprehensive patent application. Remember, once the application is filed, you are not allowed to add new matter. Thus, it is critical to include all the details you feel are necessary to obtain the best protection for your innovation. I hope you found this explanation of what a disclosure meeting entails useful. Contact us for more information and don't forget to like this video. Thank you.